Well, hello, and just like that, we are live. So, welcome everyone for this session on employment law. Hopefully, by now you know me. I've been doing this for a while. My name is Lior Samfiru. I am the employment lawyer, and I am here live right now on social media to take your questions, and not just to take your questions. That wouldn't be that much fun. To answer your questions. I'm here to tell you what you need to know about your workplace rights and hopefully help you solve some problems right now. So again, Lior Samfiru is my name. I'm a lawyer and partner with Samfiru Tumarkin LLP. We operate in Ontario, Alberta, and BC. And what I want to do right now is what I do when I'm off social media, which is answer questions, solve problems, and hopefully make people feel better about their legal rights. So if you're dealing with a workplace issue, a workplace problem, a deadline, an ultimatum, a conflict, whatever that issue is, you're in the right place. I want you to type in your question or your scenario. I'll read it, I'll answer it, and you can walk away with the knowledge that you need to have. Maybe you've lost your job. So many people have lost their job recently over the last year and a half or so because of COVID-19 or for other reasons. If you lost your job, you want to know what you're owed. Is the termination itself legal? What you should expect in that process? Ask that right now. Maybe you just found out that you're coming back to work and you want to know if you have to go, or that you're not going back to work and you want to know what that means. Maybe the terms of your employment have changed, your pay, your hours of work, your location. Whatever the issue, whatever the problem, no need to wonder anymore. Now we can answer those questions. Now, if you want to connect with me off social media, if you want to have a private chat with me, very, very easy to do that. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. That's my law firm's website. Other than just being able to read a lot of information about employment law, you'll see all my contact information there. Email addresses, phone numbers, everything you need to do to connect privately. So this is not just a social media thing. I want to be able to help you properly, and to do that, we can connect off social media. So just check out employmentlawyer.ca for that. Hey, vaccines, I know it's a big issue. Ask about that. Can your employer make you get vaccinated? Can your employer make you get COVID tests? Whatever the issue, the dilemma, the problem, the situation you are facing, I promise you there are solutions. I'm going to start answering questions right now. Ask yours. Take advantage. You have plenty of time. First question from Razor Sharp. I remember that name. I love it. My employer is posting information about staff vaccination status. Wow, they should not do that. Are they allowed to disclose this information to other employees? Absolutely not. No, no, no. They cannot do that, should not do that under any circumstances. Talk to them about it. If they continue, let me talk to them about it. One letter from me should resolve that. That's illegal. First of all, they can't even demand for you to tell them if you've been vaccinated. They can't. But to disclose that information, it's that much more severe. It's a breach of privacy rights. It's your own personal medical information. If you haven't provided written consent to disclosing that information, they cannot do that. Okay, so Razor Sharp, I think this is the time you connect with me off social media privately through employmentlawyer.ca. Not legal, not at all, completely unacceptable. Okay, so keep that in mind. Keep asking questions. I'm going to continue answering. From Tammy, can I still contact you for wrongful dismissal even though I have a union? I feel like the representation is not the best and their advice for settlement is low. Unfortunately, no. An employment lawyer cannot help a unionized employee. So pretty much everything we talk about on these sessions is only applicable to non-union employees. If you're a unionized employee, your rights are very different, but also the only one that's allowed to help you is the union. And unfortunately, when it comes to wrongful dismissal, your damages, your entitlements are going to be much, much smaller in a unionized environment. So unfortunately, Tammy cannot help you if you're part of a union. No lawyer can. It must be the union. Thanks for that, Tammy. Next question from Ria. I'm terminated with no cause after 5 years. They gave me 5 weeks of salary. I did not sign yet. Luckily, I've got another job offer. Can I both accept a new job offer and ask for better compensation? So after 5 years, you're obviously owed much more than 5 weeks. depending on your length of, on your age and specific job, you could easily be owed 6 months pay, 8 months pay, even maybe 10 months pay, months, not weeks. The reality is, if you're able to secure another job quickly, that can reduce your entitlements significantly. Before you sign, before you accept that offer, we need to speak, and we need to speak right away. You could be owed potentially 8, 9, 10 months pay. So don't make any mistakes here, because once you sign off, once you do anything, there's no going back. 5 weeks is silly. It's ridiculous, but we need to coordinate that properly with accepting that new job. So Ria, I want you to connect with me as soon as possible. Next question from Debbie. What is the legal obligation if a not-for-profit agency provide minutes of meetings to the public? And how long does a board have to respond to multiple complaints about toxic workplaces? Is it legal for emails sent to the board to be vetted and sorted so that they don't receive all the emails? So yes, I mean, they certainly can decide how to run their operations. They can absolutely release minutes to the public if they want. In terms of toxic, they have to, toxic work environment, any employer has to investigate as soon as possible. Now, depending on the type of organization and the resources that they have, the type of situation, whether they're going to investigate internally or bring someone externally, it may not happen overnight, but they can't sit on it. They can't say, well, we'll deal with it later. They have to start dealing with it immediately. The process itself may not be quick, but they have to deal with it right away. If an employer refuses to deal with it, with toxic work environment right away, or they take their time, or they're not taking it seriously, that's a legal breach. That's illegal. They have to. There could be significant consequences to the employer in that situation. In terms of email addresses that they have or releasing minutes, there's not much that can be done there. And thank you for that question. Next question from Dave Cap. I think I'm pronouncing it correctly. Maybe I'm not. With regards to calculating severance, should my employer include my 2-year disability leave as part of the length of service? I was hired in August 2016 when a 2-year disability leaves, and seems like I don't have a position anymore because of organizational structure. Yes, time on a disability leave, counts towards your total seniority. So if you're started in August 2016, now we're in, almost in August 2021, you're a 5-year employee, and your severance has to be based as a 5-year employee, meaning 6, 8 months pay, depending on your position and age, could be much more than that. You also have to make sure that the reason you're being let go has nothing at all to do with your medical leave. That's completely unrelated. So that's what you're owed. If you're not going back to work and you know that, you should be getting your severance now. Don't wait on it. Call me. Let's discuss this to make sure that you get what you're owed. Waiting in these types of situations is never a good thing. So time on the medical leave does count towards your overall seniority. Thank you for that, Dave Cap. That's a great question. Connect with me off Facebook, and you do that right away through employmentlawyer.ca. Again, employmentlawyer.ca. All right, next question from Kevin. I am so glad you're doing this Q&A. I have learned so much. Thank you for that. A few years ago, I became disabled and advised my employer that I couldn't walk the stairs where most of the jobs were situated. They gave me another job to do remotely, which did not involve taking stairs. Recently, I have seen internal job posting that I could be qualified for, but the jobs require stairs. Can my employer disqualify me for this? And how would I know if my employer passed me over because they did not? Well, here's the thing. I mean, if you're saying that the job requires stairs and you cannot use stairs, then they have to pass you over, right? If you're saying that it requires it and you can't do it, then they can't consider you. Now, if the job does not require stairs and they don't consider you, that's illegal. If it requires stairs, but it could be accommodated so that you can still do the job without stairs, they have to consider you. So the best way to do that, if in fact you are able to do the job, is to apply for the position. If you don't get it, ask questions to find out why. If the answer doesn't make sense, we can talk about it. At the end of the day, the employee has to prove that they've been discriminated against, right? But usually when someone is being discriminated against, it does become obvious. If you have the most experience, you're the most senior person, you've done the job before, and somehow magically you're not getting the job, well, it does start to look like discrimination, doesn't it? So the question, first of all, is can you do the job? If it requires stairs and you absolutely cannot do stairs, then unfortunately it wouldn't be discrimination. It's simply a matter of you not being able to do the job. So that's some thoughts there. If you think you are being discriminated against, you know what to do. You, Kevin, anyone else, you want to reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. I can't do anything for you on this session, right? I can't write a letter for you. I can't solve that problem. I could do that if you connect with me off Facebook, off social media. So please do that through employmentlawyer.ca. All right, continuing to answer questions. Amazing questions today so far, everyone. So please keep them coming. Next question comes to us from Anne. Anne says, they cut off my hours from 40 hours to 24 hours a week, and I'm on a salary, apparently due to COVID, not lack of work, and this is until further notice, but they just hired people and bought new equipment. Is this legal? It's not legal, Anne. But the reality is it's not legal even if they did have a good reason. Even if they did have financial problems, it's still not legal. An employer does not have the right to change the terms of your employment, and reducing you from 40 hours to 24 hours, that's huge. That's a massive change. So no, that's not legal. So here's what your options are. There's really only two options. You can accept the change, or you can treat that change as a constructive dismissal. It's a termination of your employment. So you can say, by changing my hours from 40 to 24, it's as if you've terminated my employment. And because you've terminated my employment, I am owed severance. Okay? And depending how long you've been there, that could be as much as 2 years pay that you're owed. So you can talk to them. If they agree to change your hours back, that's a non-issue. If not, let me help you get your severance. The problem here is this: if you continue working under these 24 hours for more than a few weeks, you're going to be considered to have accepted it. And once you've accepted it, not only are you stuck, by accepting it, you also give them the right to do it again. And then next time when they reduce you from 24 hours to 12, you won't be able to do anything about it. So you have to deal with this right now, okay? So, Anne, connect with me after Facebook through employmentlawyer.ca. Joanna, I believe I've answered your question a number of times. I see your question there. So I believe we've addressed that on previous shows a number of times. So refer back to that. Happy to connect with you if you'd like through employmentlawyer.ca. I'm going to continue answering questions. Next one is from Azadi. I think I'm pronouncing it correct. I live in Alberta. Where can I read all the rights I have as an employee? Well, a good place to start, maybe the best place to start, is employmentlawyer.ca. Again, employmentlawyer.ca. You see a lot of information there. You can also go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. It's a tool that we've created to allow you to actually get an assessment of your legal situation, to calculate your severance, to find out if you've been constructively dismissed, to find out if your matter is considered discrimination or harassment, and more. So pocketemploymentlawyer.ca and employmentlawyer.ca. And if all else fails, just reach out to me directly, again, through employmentlawyer.ca, and we can have a chat and I can help you. So thank you, Azadi, for that. Next question. Guys, bring on the questions. They're coming. I'll answer them. Love that. Question from Rena. I work for a landscaping company and don't receive any overtime because my boss says we don't qualify. Is this true, or is there a limit to the amount of extra hours I can work? So there are limits for those that are in construction. So if it's a construction type job, then correct. If it's not, then yes, you have to get overtime, over 44 hours a week. If you're in Ontario, it's different in other provinces. So if you're not sure, best thing to do for overtime, Rena, is to go through the Ministry of Labor and file a complaint there, or they can tell you specifically for your job. You can't go to the Ministry of Labor if you've lost your job. You cannot go to the Ministry of Labor if you've been constructively dismissed. But if it's an overtime issue or a vacation pay issue, probably a very good place to start with the Ministry of Labor. So definitely happy to speak to you as well if you'd like to connect with me. Again, employmentlawyer.ca. Okay, Anne says that I've been in this situation since February of this year. The problem, Anne, and Anne is talking about the fact that her hours were reduced back in February from 40 to 24 hours a week. The problem is because it's been since February, by now you're considered to have accepted it. All right, so you're now stuck. Now, the only way you could still do something is if they specifically promised you in writing that this will change at some point. So for example, if they promised you that this is going to change in July, it's going to go back to 40, and it didn't change, then the clock starts ticking again. But if they didn't promise, it was unknown how long it's going to last, unfortunately, Anne, you're now stuck because it's been 5 months, however many months it's been, that you've been working under these terms. And that is a huge problem. And there's a very important lesson here. If you are facing a change to the terms of your employment, and for example, it was a change in hours and pay, maybe it's a change in your days of week, maybe it's a demotion, whatever it is, if you continue working for any period of time, even if you're unhappy about it, you're going to be considered to have accepted it. And once you've accepted, there's no going back. And as I said to Anne, it gets worse. By accepting a change, you've given the company the right to do it again and again and again. So you may think, okay, I'm going to accept my reduction now, I'm going to be that good soldier. But the problem is by accepting that pay reduction, for example, now the company would have the right to do it again. And they reduce you by 10% and 20 and 50, and you're going to be stuck. Why? Because you let it happen that first time. You only have one chance to stand up for your rights when it comes to changes to terms of employment. Once that one opportunity goes away, you can't go back, and it gets worse. You've given the company the right to do it again. So very important for anyone, if you're facing changes to the terms of employment, again, pay, hours, days of the week, demotion, we need to speak, and we need to speak about that very quickly. Again, employmentlawyer.ca, employmentlawyer.ca to get email address, phone number. So it's very easy to connect with me and my team. And for those that have joined us, Lior Samfiru is my name. I'm the employment lawyer, and I'm here to answer your questions. I'm here live right now. If you're hearing me talk, if you're seeing me move my hands, I move my hands a lot when I speak, means I'm live. Means you can ask your questions right now. I'll see them, I'll read them, and I will answer them. So I think I'm caught up here on questions. So please, we got plenty more time, so ask your questions. As I'm waiting for your next live question, let me read a couple of emails that I've received recently, and I can answer them, and hopefully you'll learn something from that as well. In the meantime, just a quick question that came in from Tammy. Have you heard about companies not cashing out lump sum pension payouts because of the pandemic? No, I haven't. Companies have to ultimately comply with what the pension documents say and what the terms are. They can't change that because of the pandemic. That's a very important point. So the question I'm going to read in email is from Steve, who says, I've been working for my employer for the last 5 years. They just told me that my job will end in 6 months, but in the meantime, my hours will be reduced from 40 to 30 a week. Can they do that? That's a great question. We've been touching on that. So remember what I've said before, that your employer cannot change the terms of your employment. That also applies if you've received notice of termination. So for example, if your employer says your position is going to end on 6 months from now, what the expectation is that between now and the date of termination, everything stays the same. Your hours, your pay, your vacation, everything stays the same. If your employer changes it, it becomes a constructive dismissal, which means you don't have to wait till the end of your employment. You can treat that as a termination right now. So if you've received notice of termination, you can expect that your job will stay the same. If it doesn't, if there's changes, by now I know you know what to do. You contact me. Lior Samfiru, of course, is who I am, and you do that through employmentlawyer.ca. Razor Sharp asks, what are someone's rights if they lose their job due to a natural disaster like the wildfires? That's a great question. So if, in fact, let's use a situation where your workplace, God forbid, has burnt down because there's a fire and there's no more workplace for you. That situation is what we call a frustration of contract. What that means is that there's some intervening act, some act of God that made the employment impossible to continue. So it's not that your employer is letting you go. It's not that they don't want you there or that you don't want to be there. It's just employment is impossible to continue because of some sort of a natural force. In that situation, employment can end, and the employer does not have to pay any compensation or severance. It can simply end. We often see that with fires. In fact, fire is the classic frustration of contract scenario. The plant burnt down. There's no more plant. Well, I can't go to work because I don't have a plant to go to. So that's what we call a frustration of contract. And unfortunately, in those situations, the employee would not be owed any severance or payment from the employer. But of course, the employee would qualify for EI and other available government benefits. Okay, so thank you for that. I'll continue answering some questions. Got some time, guys, at least 10 more minutes to go. So please ask your questions. Next question comes to us from Kelly. Would it be considered harassment if the emails I am sending to coworkers with questions about work are being ignored? Potentially. So you're sending emails, they're not answering, they're ignoring you, they're kind of excluding you. That could be harassment. Absolutely. What I would do is I would follow up. I would say, well, I've noticed I didn't get a response. Can I have a response? If this continues and it appears to be a systematic thing, not just one of those things where someone is too busy or they kind of got lost. If it's a systematic thing, if they're doing it on purpose, yeah, that absolutely could be considered harassment. And if it's harassment, that could result in a constructive dismissal. So I would follow up on that though, and try to get to the bottom of it. It may, once you do that, it may become clear maybe whether this was just a miscommunication, an honest miscommunication, or if it's really harassment, a form of bullying, a form of marginalizing someone. So yeah, it could absolutely be harassment, Kelly. And of course, if you want to discuss this with me further, you know what to do. Just go to employmentlawyer.ca. Again, you see it on the screen right there, employmentlawyer.ca. Next question. Again, guys, you have some more time. Don't leave here without having your questions answered. So ask your question. Michelle has that next question, and she says, I'm returning to work after a medical leave. My doctor thinks I will benefit from permanent mental health accommodation, for example, part-time work or a reduced caseload. My employer told me if this is the case, they can place me within 3 hospitals as my organization has merged with them. I have worked for 20 years. I know I would not do well in another organization for a number of reasons. Can they force me to go there? And can my doctor specify the reasons as to why it wouldn't be a good fit? So an employer has to find appropriate accommodation. The more information your doctor can provide, the better. Now, if you need part-time work, and it so happens that the only available part-time work is at the other location, your employer may not have a choice, okay? But if they can accommodate you in your location with part-time work, as long as the doctor says that's going to be better for medical reasons, they have to find a way to make it happen. Okay, so the employer's accommodation doesn't have to be perfect, but it has to be reasonable. And if they can accommodate you in your current location, and if that's what your doctor says needs to happen, then they have to do it. If you find that your employer doesn't provide proper accommodation, they're not being helpful or they're not following what your doctor says, it's time for some intervention, and that's where I come in. But until then, get a very specific doctor's note. Talk to your doctor about what you need and how your employer can accommodate that, and have the doctor put that in writing. Keep in mind, the question ultimately is that accommodation that your employer is asking, that your doctor is asking for, is that accommodation possible? If it's possible, your employer has to make it happen. If it's not possible, then unfortunately your employer cannot do something that's impossible. So hopefully that helps clarify it, Michelle, but getting a good doctor's note is so, so important. Dave Cap, again, I apologize if I mispronounce it, has a follow-up question. My husband works in a company that asks its employees to sign an availability form. However, my husband was always called outside his availability, and he was warned to be terminated if he refused the 3rd time. Is this legal? So, first of all, can he be terminated? The answer is yes, because the employer can always terminate as long as they pay severance. it would not be a termination for cause. So they can't avoid paying him severance. The real question here, Dave Cap, is whether this is how it's always been. So if it's always been a situation that the company demands your husband comes in and he goes in, then that's the terms of his employment. But if it's something new that they just started, so up until now, they used to only call him based on his availability. Now they decided to disregard his availability and call him on other times. If that's what's happened now, that's not right, and that could be a constructive dismissal. So it's a question, is this always been the case, or is it a new thing? If it's a new thing, you absolutely can do something about it, and your husband should connect with me as soon as possible. Either way, they are allowed to let him go, but they would have to pay him his full severance. And if you want to know now how much severance your husband is owed, for you as well, if you want to know how much severance you're owed, or your husband or your wife, easy. Just go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You'll see our severance calculator tool there. You can find out in seconds, for free, completely anonymously, what you're owed, how many months of severance you're owed. You'd be surprised. You think you probably know, I'm owed a month or 2 months. I promise you, almost guarantee you, that you're owed much more. First place you go to, if you lost your job, or if you're worried about what you're owed if you lose your job, pocketemploymentlawyer.ca. Have a few more minutes. I'm going to continue answering questions. From Phil. Can my employer change my position hours when we return to work after COVID? So no, we talked about that extensively just a few minutes ago. Your employer cannot change the terms of your employment, whether it's because of COVID or not because of COVID. Anytime that it's a significant change, it results in a loss of pay, or your hours change in a significant way, they're not allowed to do that. But the fact that I'm saying that they're not allowed to do that doesn't mean that there's a way to physically stop them from doing it. What it means instead is you can have the right to treat the change, to consider the change to be a constructive dismissal, to be a termination of your employment. So you either accept it and continue working, and you give the company the right to do it again if you accept it, or you say, you've changed my hours or my pay or my job. That's a termination. Now you have to pay me severance. I know you didn't terminate me, employer. I am choosing to look at that as a termination and make you pay me my severance. So Phil, if that's your situation, it's not legal. You have a right to treat that as a constructive dismissal if that's what you want to do. Hopefully by now you know what to do, which is you reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca to connect with me, and I'll help you get that done. Okay, so hopefully that answers that question, Phil. We talked about pocketemploymentlawyer.ca. Let me mention it one last time. Most people, when they lost their job, when they lose their job, are offered a lot less than what they're owed. Over 90% of people, if they lost their job, are whatever they're offered, 5 weeks, 10 weeks, 20 weeks, whatever that offer is, it's pennies on the dollar. On average, it's probably half of what the employees actually owed. Okay, so chances are, if you lost your job or someone you know has lost their job, you're owed much, much, much more than what you've been offered. So what do you do about that? Well, the starting point is to figure out exactly how much you're offered. That's what pocketemploymentlawyer.ca does. We have our severance calculator tool there. You click on it, you answer a few questions, your age, your position, the length of your employment, and you're done. It's going to tell you whether you're owed 10 months pay, 20 months pay, 30 months pay. It's all there. It's free. It's anonymous. All right. Your employer may be surprised that you've learned what your legal rights are, but that's the point. You want to be informed. You want to be educated. Please don't ever accept a severance package that's inadequate. Once you sign on that line, even if you didn't know that it was inadequate, there's no going back. Every week, every day, I speak with people that have signed off on that severance package and they want my help, and I can't help them. They could be owed another $100,000 in severance, but we can't go back once you've signed. So please don't let that happen to you. That's why I keep emphasizing this, pocketemploymentlawyer.ca. That's the time that we have for this session. A lot of questions today. I'm glad I was able to get through them. Thank you very much for your questions. Your questions is what makes this session. I will be back next week. So I will be here, same time, same place to answer more questions. But if you have issues or problems or more questions, don't wait that week. Reach out to me now, today even, through employmentlawyer.ca. We have a whole team, myself included, that are going to be able to help you. So use that employmentlawyer.ca website. I will be back next week, as always. So thank you very much, everyone. Great questions. Enjoy the nice weather, and we'll talk to you soon. Bye-bye.